Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about are what you see on my screen, the Superior Court for Family Matters standing orders regarding discovery motions. And these standing orders became effective July 1st of 2021. Now, if you're watching this video, you want to make sure this video is still relevant in that you need to confirm that these standing orders are still in effect. They can be changed or withdrawn at any time. So you should just do a quick Google search of Connecticut family standing orders, and then you can see a list of family standing orders statewide. And you just want to confirm that these standing orders are still on the judicial website, in which case they are still in effect. So let me go over what the actual orders are. It says that these orders shall apply to motions relating to discovery in family matters, whether pendente lite or post-judgment. So pendente lite means, while a case is going on, like an underlying divorce, while the divorce action or custody action is still going on. Or post-judgment is when there are issues after the, divorce or custody case is finalized. So the orders apply to motions relating to discovery in family matters unless waived or modified by the court in a particular case. So unless the court says these rules don't apply, they apply. For purposes of these standing orders, motions relating to discovery shall mean any motion or request seeking compliance with a discovery request or order, sanctions other than a finding of contempt for noncompliance with a discovery request or order, an extension of time to comply with a discovery request or order, a motion to quash or issue a protective order with respect to a subpoena or notice of deposition, or the resolution of an objection to a discovery request. So it's basically saying that this rule applies to, all of the discovery issues that were just listed. And what it says is that when a party files a motion relating to discovery, the family presiding judge or the judge to whom the motion is assigned may, in the judge's discretion, option 1, schedule a hearing for oral argument and or testimony on the motion, or 2, wait a period of 10 days from the filing of the motion to afford the opposing party the opportunity to file a written objection or other response. Upon the expiration of said period, the judge may issue a decision on the motion and on any objection or other response without oral argument or testimony. Alternatively, the judge may at that time schedule a hearing for oral argument and or testimony on the motion and any objection or response. So basically, the judge can rule what is called on the papers on a discovery motion, the motions that are listed above. And what that means is they can just look at the documents that are filed by the parties and just issue a decision. Whereas most issues in family court, you file a motion, you go into court, and everybody has the opportunity to argue their position. But here the judge, so long as they give everybody a 10-day period to respond, they can just issue a decision. So I got burned on this recently, so you want to be careful of this exact situation. Is I filed a discovery request and the opposing party filed an objection, and I was somewhat careless in that I thought, okay, that I was waiting for the court to schedule a hearing so that we could have a hearing on, my discovery request and the opposing party's objection. But the judge did not the judge did not schedule a hearing. The judge just issued a decision and sustained all of the opposing party's objections and, basically sustained their objections and said that, they didn't have to provide the documentation I requested. Ultimately, it all worked out. I got the documents another way, but it was frustrating. So if you are filing, I think the exact scenario you need to be careful of is if you file a discovery request and the other side files an objection, you should file a response to that objection within 10 days of the objection being filed, because you don't want the judge, in a standard discovery request, you are not explaining why you need the documents, whereas in the objection, the opposing party is saying why they do not think they have to provide these documents. So, you don't want a judge just only seeing their argument in the objection. You want to put your argument forth. So you want to make sure that you provide a response to the objections of the other party, because if the judge just does rule on the papers, you want to make sure that you have your argument preserved and in front of the judge, so that the judge can take your position into consideration when making a decision. So, and then the rules goes on to state that notwithstanding the foregoing, if an applicable statute or practice book rule requires that a hearing be held with respect to a particular motion relating to discovery, a hearing shall be held before the motion may be decided. So there may be some discovery statutes that specifically entitle a party to a hearing. The judge can't just issue a decision on the papers pursuant to this standing order if there's an underlying statute that entitles a party to a hearing. So those are the basics on the standing orders regarding discovery motions. Again, it's just crucial that you get your objections filed or responses, replies to objections, so that your argument can make it in front of a judge. Yes, if you have any other questions, you should feel free to contact our office. And as usual, if you are looking for representation in a family law case, we would invite you to contact our office as well.